particular presentation. My name's Kyle Ingram. I'm an attorney in Washington, D.C. Today I'm going to be talking about reductions in force in the federal workforce. So the rules that apply to federal employees, that means employees of federal agencies. There's been a significant amount of talk about reductions in force coming from the new Trump administration since it took office in January of 2020. It's right now, early February 2025. So this information may change coming up. There may be RIFs, there may not be RIFs. I want to make sure that federal employees know that there are some protections that are available to them. So these are three things that you should know about RIFs and how they work, plus a little bit of background information. So the first thing is that the statutory authority for reductions in force comes from this statute, 5 U.S.C. Section 3502, which allows OPM to promulgate regulations. So what that means is that Congress has specifically required that OPM promulgate regulations. That means that those regulations can't be just taken back willy-nilly, absent some major change. But as of right now, there's no indication that there's been any move to change those or that the courts have decided to interpret them any differently. So the statute requires prioritization during RIFs with 4 different factors. Those are the tenure of the employee, military preference, the length of service of the employee, and the efficiency or performance ratings of that employee. That's built into the statute. So that's what later appears in the regulations from OPM. As far as we're concerned right now, there's no way for any federal agency to simply avoid these regulations. They have the force and effect of law, at least currently. So absent some kind of change from Congress, it's unclear what would be something that could be changed about this system. OPM has regulations promulgated under 5 CFR Section 351 that control how reductions in force are supposed to take place. These are the ones that were congressionally mandated in the statute that I cited before. So the first of these that I think is important for employees to know about is the 60 days notice requirement. Under the regulations, the agencies have to provide at least 60 days notice before any reduction in force occurs. There is a special provision for 30 days notice for unforeseeable events. I don't know how the administration comes in under that. If the administration is willing to throw away those rules, they're probably willing to throw away a lot more than just that. So there might be some kind of legal conflict here. There's also a retention register that is created. Using those prioritization rules that we talked about before in the statute and some other ones, the agencies create these retention registers. These are just lists of employees. And then they will designate the employees by where their priority is on that list. The specific way that the agencies will do this is not entirely laid out in the regulations, but it is a well understood practice that is beyond the scope of what we can cover here. Just understand from an employee perspective that these registers are going to be created in the case of a reduction in force, and you're going to be assigned a prioritization number or a class that you will belong to. And then if employees are retained, which at least at this point, some agencies don't seem to be retaining any employees. If employees are retained, then there are special rules as to how those employees are going to be retained. And that is what brings up my next point, which is bumping and retreating. These are 2 different but related concepts. Basically, they say if you are a higher graded employee and everybody's being subjected to a reduction in force, but there are still positions that are going to be filled, whether they're filled or not right now, under the circumstances spelled out in the regulations, a higher graded employee or a higher prioritized employee could bump a lower prioritized employee. And I think of that as being higher graded, but it's more complex than that. It's all of those different factors pulled together that we were talking about before, plus any others that are covered under the regulations. That could mean that somebody who is, for example, a GS-15 might bump somebody who is a GS-12. And then that person would have to find somebody else to bump. So it would flow essentially downhill. Just understand that process may take a significant amount of time, and it would depend on all of the factors that we talked about before as to what kind of positions, who bumps whom to where. There are a couple of limitations, such as, for example, there is a 3 grade level bumping limitation. So if you're a 15, you can bump down to a 12. but you can't go to an 11, for example. If you are a person who is a veteran with a 30% or greater service-connected disability, you can bump down to 5 grade levels below. The whole point of this is to retain the best individuals for these jobs that the agency can. Retreat rights are a similar concept. Basically, with bumping, you're going to a job that you may never have done. With retreating, you're going to a job that you previously did before, or it's something that is similar. So if you are currently at 15 who's doing management level work, and previously you were 14, 13, 12, you can retreat to your prior position as a 12. That's possible under these regulations. Again, that requires that job still continue to exist, which for some agencies with this new administration, that may not be the case. So these are all ways of saying that agencies are going to set up these reductions in force, and they're going to use these lists to basically put employees into competition with each other for the remaining jobs, if there are any. Hi, Kyle here. I want to take a brief moment to speak directly to the federal employees who may be facing workplace discrimination, retaliation, or other workplace issues. These matters are complex. You shouldn't have to do them alone. I offer free 15-minute consultations throughout the week to federal employees to discuss these matters. To schedule your consultation, click on the link in the description below or go to kingramlaw.com to schedule your time to speak with me. Let's discuss how I can help you protect your rights. Regulations say that if there is something illegal about the way that the reduction in force was conducted, that can be taken to the Merit Systems Protection Board. OPM has designated MSPB as the place to take all of these reductions in force. If there are massive reductions in force, as seems to be the plan with this administration, though they haven't yet sent out any notices that we just discussed, at least at this point in early February 2025, OPM's regulations say you have to go to MSPB to challenge that. Please know that with the MSPB, deadlines are very strict and very short. They may be 30 days, they may be shorter. You should definitely contact an attorney very soon after you are either given notice of a reduction of force or you've been reduced in force, either through a termination or through a reduction in your grade, anything like that. Talk to an attorney about this because these are not easy issues to disentangle. There are things that are covered by RIF rules. There are things that are not. And so that brings me to the next point, which is some actions are deemed voluntary. And for example, if an employee were to take a position that would excuse them from the reduction in force, but not as part of that reduction in force, so not through bumping or not through retreat rights, then that likely would not be covered by the MSPB's jurisdiction. It would not actually be a reduction in force because it's a voluntary taking of a different position, even if it results in somebody taking a position where you're getting a lower, you're getting a lower grade, significantly different duties, things like that. Anything that is voluntary is typically outside of the scope of what the MSPB can do something about. There are a ton of exceptions to that rule, including if you're forced to take it. So the circumstances really matter. You should definitely talk to an attorney about any of these issues. Thank you for listening today. I hope this has been at least somewhat enlightening as to employee rights for reductions in force. If you are seeking assistance with an issue related to a federal agency's reduction in force, including your position, I would highly recommend that you reach out to an attorney who is experienced in these kinds of matters to be able to discuss what your options are. You may have very limited time windows in order to be able to do that. And that's one of the things that I can't stress enough, because if you wait too long, you will lose your rights.